Hi guys, it's Kathy. I hope you're doing well. YouTube is slow to wake up this morning. I hope it goes live. All right. We got a couple different clips today, but mostly Texas. New judge. I like her. I like the court. It has interesting stories because it's bond reconsideration hearing. So, interesting stories. But first, we're going to start with the most boring. It's just a few minutes long. How many minutes? 12. Because not a lot of people are here yet. So we'll start with that. And you'll see. Here. Let me just show you. Let me just press play.
All right, I think we got our broadcast going here. This is 4499 Michael T. Gertken versus Trace Generations Management LLC, Trace Generations Limited, the estate of Richard Anthony Pergo and Charles Timothy Gertken, here in the 452nd Judicial District Court of Edwards County, Texas.
Yay,
We're
Kelly,
here without
thank
record
you.
today for a hearing on defendants' traditional and no evidence motion for summary judgment. This is filed by Mr. T.J. Jones, who's present representing.
Listen, I didn't do it on purpose, Eileen. I didn't do it on purpose, Eileen. I had no idea. Oh man, we were looking for you yesterday. Yeah. Yesterday we did Judge Fleischer. We did an older. We just redid one we did a while ago, and Ramona was there, Melissa was there, Victoria was not there, but Victoria was in chat, so you saw her messages pop up on screen, and Louise was there. Yeah, yesterday we did Judge Fleischer again.
His clients, which are the two entities, as well as the individual Charles Timothy Gertken. Mr. Sacco is here representing the estate, and on behalf of the plaintiff, we have Mr. McNeil. So take it away, Mr. Jones.
And Judge, just a point of order. I know that you said that you'd give me time to go through everything and then allow Mr. McNeil to respond. This was a no evidence motion for summary judgment as well as a traditional summary judgment because there was no response filed to the no evidence portion.
Okay.
I don't want to waste the court's time going through a long recitation of the facts for the traditional side since the no
Okay.
evidence side.
That's fair. So I do have defendant's response.
Dumbass.
And
that's our response.
Sorry, that was filed by Mr. Sacco, I guess. Yeah.
You're on.
Mr. McNeil, okay, I apologize. Yeah, so we have a no evidence motion, kind of a deep.
So we see pro se's do this all the time because they're not lawyers. Tina, hello, Tina. Tina has been subscribed for 4 months on Twitch. Thank you, Tina. Thank you. We see this all the time with pro se, but rarely ever do I ever see this happen in one of these courts where it's just a bunch of lawyers. He didn't file a response, guys. He just didn't file a response. That means we'll see.
Default on the no.
Well, Your Honor, we're going to rely on the evidence which the defendant had supplied. He extensively, as you said, about 600 pages. The wills, the deeds, various corporate documents and whatnot. They're claiming superior title through amendments to the corporate documents that were made by the parents.
Okay, before you drill down into that,
Yeah.
So I do not a whole lot of summary judgments. Mainly, as you can imagine, we do a lot of
Yeah.
felony and divorce work out here, but we have our fair share of civil cases of summary judgment. Now, when there's a no evidence motion filed, I think the rules are pretty clear. You have to file a response and attach your evidence to the response to the no evidence motion. Do you want to speak to that, Mr. McNeil?
I believe that I
Dumbass.
can rely upon the evidence supplied by the defendant.
No, you can't. And we all know this. And none of us are lawyers. Every single one of us here knows you have to file a response. You just have to. Because if you don't file a response, it's like you didn't even show up. Guess what that means? Summary judgment, sir. You lost.
But
Okay, do
there
you
is
want to point to me? Do you want to point a
Yeah.
rule or a case to that effect?
yeah, give me a second.
You're going to need
Okay,
more
while
than
you're
a second,
looking that
sir.
up,
There's also an answer from the other party as well, Mr. Seiko's client concerning this. So there is an answer on the record.
I'll get to him in a second. So yeah,
Yeah.
I was confused. I didn't look closely enough to see that the answer was filed by Mr. Sacco. All right. So while Mr. McNeil's looking for his rule or case law, Mr. Jones, do you want to speak to the question?
Yeah, absolutely. What Mr. McNeil is basically saying is, well, we should be able, as the plaintiff in a trespass to try title action, we should be able to rely on the evidence supplied by the defendant to combat the claim for title. In other words, they're saying,
No, dumbass, shut up. Why are you saying that? He didn't respond at all. Summary judgment. That's it. It's over. Why are you saying all of this? Kelly, thank you so much. Oh, I hate that you have headaches. I hate that. Ugh. All right, let's see this lawyer talk for absolutely no reason.
they have not shown, they being the defendants, have not shown a superior claim to title to the plaintiff. That's not how trespass to try title actions work. If you look at footnote 49 of our brief, page 14, the plaintiff in a trespass to try title action must rely on the strength of their own title. They can't simply attack the title, record title of someone else.
Also getting into the weeds a little bit. I'm just talking about procedurally on a motion, a no evidence motion for summary judgment. What's required under the rule?
There has to be a response filed, Judge. There has to be a response filed. That's not cited in my motion because I didn't anticipate that response wouldn't be filed. But as far as the no evidence motion goes, the plaintiff must file a response and attach evidence to support their claims. And without a response on file and without either a request for continuance or some other reason why a response wasn't filed, then the claims must be dismissed procedurally.
All right. And so are you seeking just a ruling upon the no evidence motion today?
I'm seeking a ruling on both the traditional and no evidence. The order that I submitted was a blanket order granting both the traditional and no evidence portions, but I think that the traditional part of our motion is really no longer at issue if the no evidence portion is granted.
Okay, so do you want to respond to that particular procedural issue, Mr. McNeil? The issue that there is no response filed to the no evidence motion on behalf of your client, the plaintiff.
Yes, Your Honor. I'm getting this here. The non-movement, which is myself, has the burden. Hold on. Some reason my phone is ringing. All right, I'm sorry. Yeah. The non-movement, I bear the burden of pointing to evidence in the record that raises a fact issue on the challenged elements, right? I understand that it's considered fatal, but like I was arguing that he has supplied evidence, and the evidence that they're relying upon to show superior title is disputed. That is you know
Besides the
what
point.
we're going to
No, you're not.
argue.
No, you're not.
Okay. All right.
And then
My phone is ringing.
yes, I understand that if we didn't file the answer within 7 days, the court can presume and grant the motion.
Which motion? Say it. Say it. Say it. For summary judgment.
But I'm trying to look at the civil procedure.
While you're looking around there, Mr. Sacco, do you
You can look all day, but we don't have all day. Kelly is on a 25 stream streak over on Twitch. Wow. Good job. Thank you. Yes, you do. Yes, you do, girl.
want to tell me your opinion?
Yes, Your Honor. Just briefly, we
Response.
did file a response as co-defendants, and our response does touch briefly on the no evidence motion. We have an affidavit that's attached to that, so I believe we've provided evidence to create a genuine issue of material fact as to the movement's claim, specifically the assignment of the interest in the entity.
Judge, I can respond to that.
Okay, go ahead.
Judge, this is probably the first time that I've seen a co-defendant that does not have counterclaims or cross claims file a response to a summary judgment motion filed by a co-defendant.
Yeah, okay. You can stop there. Yeah, so there that was my question. If Mr. Sacco had pleadings on file, is there any I guess common law, case law with regards to that particular issue, Mr. Jones, that you're aware of?
I have never seen that issue, and I briefly tried to find something on the issue and I couldn't find it. I think that you default back to the summary judgment rules. Mr. Sacco's response is largely irrelevant to
Okay,
our
I got you. Do you want to speak to that issue, Mr. Sacco? The fact that you don't have any counter pleadings, and it is unusual. I think it's the first time I've.
Well, and I don't know that the position in their summary judgment motion was made clear in their response, their answer. So I don't know that we would have had an opportunity to make a counterclaim specific to their claims in the judgment, the summary judgment motion. So we're responding to what they're putting forward.
Okay, so I think I don't know that I need to hear anything else today. I think what I would do, Mr. Jones, is ask you to submit an order granting them no evidence motion for summary judgment. Let me get my T's crossed and I's dotted before I make a decision there. It may be that I call you back for additional
Dog ate
information,
it.
but it may be that I grant the no evidence motion without further participation. So if you'll submit that order, Mr. Jones, you'll have a decision from me.
We already know your decision, Judge. You don't have to talk anymore either. You can just relax. Sorry, I know that was just lawyers, no meltdowns or anything, but I was watching that and I couldn't stop saying, dumbass. You dumbass. I can't believe you did that. Okay. Now we're going to Texas. to a different kind. Okay, this is going to be interesting. Yes, sir. Yes, sir. Hi, Lucy.
Ace, I think probably we're up and running
Welcome,
now.
James, by the way. Welcome. Welcome.
All right. Okay.
Thais, well, let's get Thais to confirm that. We are, indeed.
Okay, so we're up and ready to go.
Yes.
All right then. It's 1:04 p.m. here on October 21st, 2025. And
It's really not 1:04 p.m., guys. Don't listen, please.
this meeting of the Complaint Review Committee of the Guardianship Certification Advisory Board will begin. First order of business is to call the roll. Jason Armstrong,
Here.
Leonard James,
Here.
Nathan Peters,
Here.
Judge Spencer,
Here.
and I'm Jamie McLean. And it looks like we have a full board, and a quorum is certainly met. So from that, we'll move on to opening remarks from the director.
Mr. Chair and members, thank you all for your time today coming together for this meeting. We really do appreciate the hard work and efforts of the staff in particular who bring matters such as the one that we're going to address today before this advisory board, and we're grateful for your time in being willing to hear them. I will point out, without giving specific numbers, that staff are working very hard at getting rid of a backlog, although admittedly not so much in the guardianship world, as there are fewer of those complaints, but complaints in general. And so as we continue to move through that backlog, you'll start to see a few more. But the other thing that you will see happen, such as is the case with item 3B, is that we continue to work towards the right disposition, the right outcome on each of these, which is why we ended up for 3B with a settlement today. And so you will be proceeding only on one matter. And with that and our gratitude, I'll hand it back to you.
Okay, and on that matter, do we need to take any action with regard to the settlement, such as recommending it to the full commission, or?
No, you do not.
Just to leave it?
Nope,
Okay.
you do not.
All right, then. We'll move on to the matter for discussion today, which is 3A, in the matter of Sandra Evenson, cause number 0825. And with that, I believe I'll turn it over to the staff to brief us on that.
On March 25th, 2025, Melinda Saucedo, compliance manager with the commission, filed a complaint against Sandra Evenson for continuing to act as a certified guardian after her guardianship certification was revoked by the commission for a period
Monica,
of 3 years.
thank you. Thank
The
you,
respondent did
Monica.
not submit an answer or return any of the commission's phone calls or emails. However, her certification was revoked prior to the filing of the complaint.
We did find a violation of Commission Rule 7.2A1, and we're recommending the permanent refusal to approve the respondent's private professional guardianship certification and assess an administrative penalty of $500 against her due within 12 months after the date of the final order for this violation.
Okay. Did all the members of the committee have a chance to review
Yes.
the violation? Are they materials? Okay. Is there any discussion?
We're going to hear the answer to that question in a second, Amy. Don't worry.
I have a couple questions. First of all, I was on the commission when when it was revoked in August of 23, so I probably participated in that and have some reservation about being involved in this, but it looks like there's a quorum otherwise.
There is a quorum, Judge. Thank you. Joshua, the cat, been subscribed on Twitch for 4 months. Woo! Thank you.
But she would also now owe, I think, $4,000, correct? The $3,500 she didn't
Yes.
previously. But my recollection is there are not really any enforcement provisions available. Is that also correct? I
Well,
mean,
the only thing we can do, Your Honor, is to refuse to renew, or and or issue an administrative penalty.
So we can't go chase her for the $4,000.
We can, but it requires jumping through a number of hoops.
Possibly requiring more staff effort than is justified under the circumstances, perhaps, right?
Perhaps.
So, and I may actually even have created some of those guardianships when I look through them, and just to speak, while I don't think I should vote, I'm in agreement with what the recommendation is, but to speak on her behalf, I looked at those guardianships and virtually every one of them is an IDED, maybe mentally ill person, and they're exceedingly difficult guardianships. There are virtually no guardians available. She wanted to do a good thing, as she said in some of her responses, and was simply not able to keep up with all of it and actually work, which she needed to do since there was no way she could get paid for a lot of these. And while she should clearly have paid more attention to it, she took on some big jobs, and there appear to be looking for other people to handle a lot of them without a great deal of success, which just speaks to the need to supplement the available guardian pool. So those are the things.
And Judge Spencer, for what it's worth, I think that at some level the commission has historically, and you can speak to it from your role on it, the commission has historically recognize the lack of guardians in the state of Texas, and the difficult position in which guardians are placed when they take on these very challenging, complex guardianships, and we are in a very tough spot in that regard. I do, however, appreciate your willingness to I guess the technical term, and I'll look to Vina to confirm that I'm right or not, is to recuse yourself on the ultimate decision here, given your prior exposure to the case and potentially your role with respect to her guardianships. And so, while we are aware of the challenging spot guardians are placed in, unfortunately, what we have before us is the instant matter, and that's where we land. And obviously that is what our staff has brought to this complaint review committee for their consideration.
Yeah, and I want to be clear, she wasn't a licensed professional guardian during my time at the courthouse, but some of those guardianships are fairly old. And I looked at them and I thought, oh, I recognize that name, and I recognize that name. And as I said, I may have created some of them, and she took over as a successor guardian in several of them, as far as I could tell. And so I felt the need to speak on her behalf, but I don't think it'd be appropriate for me to vote.
Understood.
And just for clarification, so the only county we're talking about now is Bexar County?
It appeared to be correct.
That's correct.
Okay. And has the staff been in contact
Judge
with the
Boyd.
current Bexar County probate courts?
And I'm sorry if I can jump in right quick. That we know of, Bexar County is the one county that we know of. I can't say definitively that, she's not in Atascosa or any of the surrounding counties, Guadalupe. And so those are the ones that I was aware of. It's difficult, and I know Judge Spencer recalls other guardians in which were across Texas, and often if they aren't registering the guardianships or submitting their annual reports, we don't necessarily know what counties that they're in. But from working on her cases as an investigator myself, I recall that she was pretty much just in Bexar County. So I'm hoping that we were able to I guess have her just limited to that. But definitively, I can't say that for sure.
And
Okay.
actually, excuse me, that's a good question. Did you inquire of the surrounding counties? Because she might well have, in my opinion, more likely to have been in Kendall, Comel, or Guadalupe, because I suspect that they'd be a little more active in creating some guardianships than some of the others, but
And unfortunately, I can't remember. I've had such an influx of initiating the complaints lately for all of the professions, unfortunately. And so I don't quite remember what brought this to my attention, but what I can say is that I do kind of a search as much as I can in all of the court databases or whatever that particular county uses to see if I can bring anything up. Now, I don't recall, but I'm usually pretty good about contacting the other counties, but I can't say that again definitively. I guess that's going to be my phrase of the day, unfortunately.
Okay. Has anyone from the staff been in touch with the Bear County probate courts?
Yes.
And so they are aware of the revocation.
Yes, they were aware of the revocation before, and immediately when I was speaking with them, they were immediately taking her off of all of these cases and finding either successor guardians or appointing a guardian ad litem to go out and assess whether these cases needed to be closed or if a guardianship needed to continue.
Okay. And of course, as Judge Spencer just said, because there's a lack of guardians to take on these cases, that may very well take a while.
From my understanding, she has been removed from all of her cases in Bear County.
Okay. So she has no current cases in Bear County.
No.
Good. Okay. Very good.
And I think, Mr. Chairman, I think it is also of note that staff made attempts in several ways to reach out to her, and those attempts were fruitless, and we have had no contact with her with respect to this matter.
Okay, thank you. All right. Do any other members of the committee or staff have questions or comments?
I had a quick question. I was reviewing the packet and I saw she did respond to an email on August 9th of 2024. Is that the last time that the commission has heard anything from Miss Evenson?
I think everyone's scrolling to check those emails.
What you're seeing right now is furious scrolling happening by staff.
Sure. It was towards the beginning of the packet, around page 30, I think, is where I saw she had at least communicated and shown, because I guess my concern is she even still alive if she's disappeared and none of the addresses are working?
Yes. That August, yes, I found what you were looking for. The last time that the commission has had contact with Miss Evenson was for her previous case. So the last time Miss Evenson communicated with me was April 24th, 2023. This email is between her and the courts. When I did speak with the courts regarding this case, they stated Miss Evenson, was filing documents in their court. Then they said it stated an attorney appeared on her behalf and just told them, Miss Evenson is overwhelmed right now, because we did have the same kind of concerns of, is she okay? That kind of thing. From our understanding, yes, she's out there. Just, I guess an attorney was working on her behalf.
I do see a LinkedIn profile for her showing as a current senior human resources coordinator at some place called Well Central Health in San Antonio, and she's held that position for 4 years. So
yes, and she's maintained that other job, and I don't know if this was kind of a side job or if she was transitioning, but she's always had in which she worked in facilities, I think, or placements.
Hi, CJ Love.
yeah, I don't have any further questions. Those were my main
Thank you.
questions.
Okay. Any other questions or comments?
No.
Okay. Anybody have a motion to be made? Okay. I will then bring a motion to accept the staff's recommendation and recommend a permanent refusal to approve respondents' private professional guardianship certification and assess an administrative penalty of $50 against the respondent due within 12 months after the final date of the order for violation of the commission rule 7.2A1.
Mr. Chair, can I ask you to reconsider your motion? I think the staff's recommendation was 500, not 50.
Oh, I said 50.
You did.
Yes, please, definitely amend that to 500. Yeah, and forgive my misreading of that there. I meant 500. So let me rephrase my motion. I move that we permanently refuse to approve the respondent's private professional guardianship certification and assess an administrative penalty of $500 against the respondent due within 12 months after the date of the final order for violation of Commission Rule 7.2A1.
And I second.
Okay, all in favor? Aye.
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 That's a
And
four votes.
I recuse myself.
Yes, and I believe Judge Spencer is going to recuse herself, so that's makes all of the voting members have voted for the motion. Motion carries, and that recommendation will be made to the JBCC.
I feel a little sad for
Yeah.
her. Obviously, she shouldn't be a guardian, I guess, because it was too much. But she has to pay $4,500 now when she was just trying to help. Okay. The camera wasn't working, guys. So I had a decision to make here.
Are you represented by counsel?
The camera just wasn't working. So they don't have a camera. It's 21 minutes long. And if you guys hate that there's no camera, I will turn it off. Okay? And you don't hear her great, but it's a really good clip. The judge recused herself because she sort of appointed this person and was around for the first round of in 2023 she got in trouble before, and the judge was part of that. So all right, here we go.
Okay. Why don't you come forward, Miss?
This calendar like this.
I put the captions on. They're probably not going to get it right, so it should be fun too. All right, we put her on because she wanted
the
Oh, okay. Okay.
we appointed.
Which?
I am not represented by any member of this board. I am never.
Okay. All right. So, Miss Westfall, I've got you on you're early and I appreciate that. We've got you on the 10 o'clock calendar.
I wasn't sure, so.
Yeah, no, I appreciate it. So go ahead and say, what I've got on this is my understanding is you're pro se, but that Mr. Haverco might be available to answer any questions you have.
Say is determined that you all have assigned to it.
Okay.
Sui juris is the way that I'm capable of speaking for myself. And
Okay.
I can understand your process.
You don't.
No.
Okay.
I'm not.
So Ms. Westfall,
Not.
right. Well, Ms. Westfall, what we're going to do is ask you to have a seat, and then we'll get to your case in just a second. Okay.
As long as I'm not just waiting until 10 o'clock, it seems like everybody else is waiting for something.
Well,
There's a reason we can't continue this if I'm speaking for myself and I'm sitting here.
well, so the record showing we do have Mr. Haverco listed as your attorney to help
I
you.
did that. I never approved that. He called me the other day and I told him we never approved that. We never.
I think we want to mention the word Steve.
Yeah. that's-
Sue juris.
Yeah, she,
Every time I've been here, I don't know why I'm so.
Hey, Mr. Westfall, I want you to hold on a second. I'm going to hear from Mr. Haverco, please. So just please, you will. And I'm going to give you, you're going to get a chance. Just give us a second. Let me hear from Mr. Haverco and we'll get this cleared up. Mr. Haverco.
I believe I was appointed, but then I went to make contact with Ms. Westfall.
Is there an armed guard by him?
Ms. Westfall. Ms. Westfall, he's security for the courtroom today.
He's not just armed.
He's security. He's a police officer. He's security for our courtroom.
He seems intimidating right now.
Mr. Haverman, go ahead.
Well, then, that security guard can go home feeling good because he seems intimidating right now. Yeah, he's supposed to be. His whole job is to intimidate you. That's what he gets paid for. Good job, sir.
Figured. So I'm James West call us to, do some preparation for the trial hearing, figure out what we're gonna do. And then she mentioned she was
Recharge.
and right, which that's what that means. It means you're confident and you're able to indulge. So I asked her, sounded like she wanted to represent herself pro se. And she said no, just to be kind of particular about it. I think what she probably means is that she's confident by way of the senior jurors that have been allowed her to proceed pro se because pro se you represent yourself.
Your sole purpose would be to assist me in your process. It's not for guidance or speaking for me in any form, fashion, or.
Okay.
So I guess based on that, I make a motion to withdraw. She can say if the court wants to inquire with her about what would then be expected of her as far as her confidence and having to be familiar with the court rules, procedures, potentially alleged rules.
Well, here's the thing, I do not plan on proceeding with this case.
Oh, that's right. The other thing, if I can just add.
I want you to prove that you have the right to waste my time.
So one of the issues, just for the court's information that she brought up, I said, well, if you're going to proceed, then what are you going to do with your case? And she said, I think something in fact there won't be a case because there won't be a court.
Okay.
And I said, what do you
When I prove that this court is part of the stalking case against me by way of Lewis County Junior, I believe it was a private cop. I think right now you guys still have a chance to see that I'm not the wrong person here. I think you have a chance. But if you proceed with these charges against me, I'm willing to die on this hill.
Okay. All right. So, Ms. Westfall, what I'm hearing you say is that you do not need nor want the assistance, the coaching, the ability to contact or utilize the services of Mr. Havercom. Is that
You
correct?
can be a translator.
I don't have any training.
Just from your jargon to layman's terms.
Okay. Now, explain to me what that means.
Well, I didn't go to all of the schools that you all went to, so I don't know what you call certain things.
Okay.
So I don't want to use the wrong word and have that used against me because you guys use a different dictionary.
Okay. So what I'm hearing you say is that you would like to proceed pro se, which means with no lawyer, but you would like the ability to have Mr. Haverco sitting there. If a word comes up that you don't understand, you can look at Mr. Haverco, like I may not understand a word, and I might say, Mr. Haverco, I need you to explain this word to me. Okay.
It makes me a little nervous because I know words that he doesn't know.
I get it. And he knows a lot of words I don't know. I don't think I know any words he doesn't know. But the question then is, I have to appoint him to do that, which appointing means I need to put you on his calendar. But again, I understand it's a limited appointment.
Talking in circles here because
Yeah.
I do not plan to proceed with these fake charges against me. I am going to sue every person that attempts to traffic my person any further.
Right. And I understand that. But
I'm here today just to let you know that I will not be back to this courtroom.
okay.
And if you send your thugs for me, I will sue each of them too. I will name every person when I get these charges filed because I'm being trafficked.
Okay. All right. Let me stop you for a second. Now I'm going to turn to the city. Mr. Ratfield, does the city intend on dismissing the charges that are currently pending against Miss Angela Westfall under cause number 5A 065-7399 to charge of theft. Does the city intend on dismissing those charges today?
No.
Okay.
I am shocked. But sir, she is going to sue you for trafficking if you go forward. What do you mean you're not going to dismiss?
What would the city like to do with Ms. Westfall's case today?
The city would like to set this for the trial confirmation. On December.
Okay. Hold on, Ms. Westfall, just please.
Right, traffic me.
I'm just making sure we're gonna get everybody on the same page here. So I have a request from the city. And I think I have a request from you, Ms. Westfall.
My request from you is to cease and desist.
I understand, but I also think there's another request on the table, which is to allow access for you to utilize Mr. Haverco for purposes of explanations as it might relate to certain words, certain processes.
Knowledge. This is-
Okay. All right.
If she, if I would come and she doesn't press my knowledge, I'm not sure what the purpose is.
You're right, actually. So no, I won't be in services.
Okay. So you do not need his services.
Yeah,
Okay. So you're asking that we allow Mr. Haverco to withdraw.
I'm asking you to withdraw your case.
So based on that, I will allow Mr. Haverco to withdraw as the appointed counsel.
Who else is so happy for Mr. Haverco right now? Good job, sir.
Hey, Ms. Westfall.
I will call for the time. I will be here. Do not send your thugs for me.
So let's have a discussion about Ms. Westfall. So she just left court without notice, without the conditions. We've got a couple options. I'm not a big contempt person, just so you know. I think that court is stressful for lots of people. I think court is.
This is Yelm, and this is the nicest judge I've ever seen, which is why I hardly ever even look at his docket, because I know I know you guys want to see contempt, but I looked at it yesterday and this is what I got.
Difficult for lots of people. She's indicated on the record that she indicated December 4th for confirmation. I'm inclined to give her a little bit of grace here and just set it for December 4th. We mail notice. We have an address.
I can mail notice. I'll
Okay.
see if it's a good address. I know
Why
I've
don't we
mailed
do that?
before.
We've seen Ms. Westfall
I'm going to put it on my calendar real quick. December 4th.
completely normal.
Right. And I think I've seen her different as well.
So I think just the report, you could see the different ends.
Okay. So why don't we set this for December 4th at
Probably 9 a.m.
9 a.m.?
since she's gonna resign.
Right. December 4th.
Should I do the pretrial conference order or just a
Pretrial.
hearing notice? Okay. Because I don't know, there's a lot of.
Is it for confirmation on December 4th?
Yeah,
let's
okay,
talk
so
about-
pretrial confirmation. Okay.
Okay.
Let me.
I will note she's had no new law violations since July. So
Okay,
she's in compliance with her conditions.
Same.
That is.
Okay. So with Ms. Westfall's matter, resetting it to December 4th at 9 a.m. For the record, Ms. Westfall noted verbally that she was aware of the December 4th date. She also indicated she was capable and would contact the clerk's office to confirm that date. We're going to mail this notice to the address we have on record and that probably DOL has on record.
Yes,
for Ms. Westfall.
we mailed the last order and it didn't come back. So
Okay.
it must be a good address.
And it'll be on for confirmation. Mr. Haverco has been allowed to withdraw from her case. And I know for the record, Ms. Westfall's had no new law violations since July. So We're good.
What the? I gotta rewind it because I don't know what the caption said, but that's not what he said. Okay, we're at 11:15. I'm probably gonna rewind it too far, but I gotta see this again.
Confirmation, Mr. Haverko has been allowed to withdraw from her case. And I know for the record, Ms. Westfall's had no new law violations since July. So we're good. I signed that order.
That's not what I read, but that's fine. That's
She
better.
Yes, that was a technical case.
There you go.
Thank you.
Okay, so we have
I left the next one in too. I know there's no camera, but it's fine. It's not as good, but it's okay.
what, are you here for court?
Yes.
What time?
10 o'clock.
What's your name?
David Campbell.
All right, Mr. Campbell.
Now I want tomato soup.
Oh, there we go.
Okay. We're on record.
All right, we're back on the record. And is this Mr. Linford? Now, is your first name Seven? So what?
Just like
Okay. All right. I didn't know if somebody left that out. There's a sign, isn't
Seinfeld.
that's right. Okay. Seven, because Mickey Mantle was number 7. It's a classic Seinfeld episode. Is that how your parents named you? 7?
I'm born in Vegas. Parents is after 7. Lunch and cheese and things like that. I married the children, and the mom said, "I'm gonna have a kid and named 7. He's my favorite." That's what I got.
Okay. You got it. I got it. That's a great backstory. So I agree. And it's a great name. All right. Mr. Linford, you're here on obviously multiple issues, represented by counsel. You are Mrs. Blackburn? No? What's your name? Yeah.
No, Trisha Blackburn is the.
Oh, the Victor. I'm sorry. I'm sorry. I misread that. What? Yeah. What's your name?
Attorney Cruz, Your Honor.
Cruz. All right. Good morning. And what are we doing with Mr. Linford's case today?
I will let City make its motion, but we do have an entry of the on one count.
Yes, Your Honor. The city has reached a resolution with the defendant. The city is moving to dismiss 47 counts against Mr. Linford in exchange for Mr. Linford pleading guilty to 1 count.
All right, Jim. Before you lose your shit, because I know you're about to, Jim. Just wait. Just relax, because they're not. So, what I think is he stole 48 different items at the same time. Okay? And they charged him with each and every single item. So now he's pleading guilty to 1 count of theft or burglary or whatever. You know what I mean? So like if he stole a box of crayons, 64 crayons, they could charge him 64 counts, and that's what they did. So then they get to court, and he's like, okay, I'm just going to steal one. It's just going to be one box of crayons. So.
All right. Mr. Linford, let me get what we've got over here. All right. All right, you are 7 Linford. All right, Mr. Linford, I've been handed forward a statement and defendant on plea of guilty to specifically cause number 5A06625557.
Number 8, Your Honor.
Okay. And did you get enough time to go over this with your counsel? Okay. So, Mr. Linford, this is a charge of violation of protection order, and as I'm hearing, the city's going to move to this. You have 48 of them. Okay. If I accept this plea, the city moved to dismiss the remainders. And in this particular case, you're charged with violation of a no contact order alleged to have occurred on or about August 23rd, 2025. Now, this charge is what's called a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendation in here that I don't have to follow. I can sentence you up to the maximum.
He sent 48 text messages. They charged him with every single one of them. So they just bumped it down to the one.
Okay. And you understand by pleading guilty, you're giving up a number of constitutional rights that are contained in paragraph 5 of this plea. And did you read this, or did Ms. Cruz read it to you, or a combination of both? Both those things? Okay. And you feel like you have enough time with Ms. Cruz to go to she had all enough time and you to answer any questions you've had, and you've had enough time to ask any questions that you have? Okay. All right. So paragraph 11 contains a statement that says, on or about August 23rd, 2025, I knowingly violated a no contact order by having electronic communication with the protected party. The protected party in this case was Patricia Blackburn, an ex-spouse. Is that your statement? Okay, so as to the charge of violation of a protection order, one count alleged to have occurred on August 25th in the city of Yelm, how do you plead guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily. No one's made any threats, any promises of any kind to cause you to enter the plea. And I'll accept your plea. I'll sign the statement of defendant pleaded guilty. Are we moving to sentencing today? Okay. I'll hear from the city first.
Your Honor, I believe it's an agreed recommendation of no time, no fine.
Okay. Ms. Cruz.
Thank you, Monica. Thank you.
As to why to negotiate there are some mitigating factors here. I believe that after this, and for a fact that I will see the back here, I know this number of counts is alarming to the board, as it is to my client. I think that I made it very clear if we weren't able to work out such a resolution, what could have happened. So he knows, and he is fully aware that he will not be having any communication with Ms. Blackburn. And I do share a child in common, so there will be some things to the court or family court, and that's to be expected. But beyond that, I believe just even personally, my client has moved on. He's in a different relationship. He's in a different period of his life than when these allegations were alleged to have taken place. And this was taken place. So things have calmed down since then. And I believe that my client, he works hard at his job. I believe no jail is necessary here. Thanks for starting with some financially. So I believe that time is also appropriate.
All right. All right, Mr. Linford, you have the opportunity to say something. You don't have to say anything if you choose not to, but it's your opportunity. Okay. All right. So, Mr. Linford, obviously your lawyer kind of summed it up. You could have been buried by this. Again, I don't know all the facts surrounding it. It looked like it was all electronic communication, which tells me it was probably texts. And so you need to understand that one text message is a violation of an a no contact order because it's contact. So each time you contact, it's an individual allegation. It'd be, this isn't a great analogy, but it's like poaching razor clamps. you poach 50 extra razor clams, they can charge you for poaching one, or they could charge you poaching 50. And that's kind of just, prosecutorial discretion. I've really seen it going both ways. Your lawyer probably has too. So, hope you're in a new space. The problem is, you've got a child in common. You also have somebody that,
It's Judge Pro Tem Christopher Coker.
for better, for worse, you've got family law that's going to be involved. This is a business relationship moving forward, and you need to understand that. Okay. And you need to double, triple, quadruple check if there's any orders, language, what you can and can't do. When in doubt, don't do it. All right. Okay. So
Yesterday was Judge Fleischer. Yesterday was all Judge Fleischer.
I'll follow the recommendation. I'm going to impose 364 days in jail with a $5,000 fine. I am going to modify this a little bit. I am going to impose a $250 sort of monitoring fee for probation. Reason I'm going to do that, this is a lot of paperwork, a lot of charges, a lot of work by the police to do this. So I do think the city needs to recoup some of that.
If no one saw Maria say, hello, top messages, people, that means you're on top messages. Go to live messages, guys. That's hilarious.
You can make payments on that. You're to appear timely at all court hearings. You're not to have any criminal law violations, and you are to abide by all prohibitive court orders, including no contact. Do you understand that? All right. Any questions about anything?
When do I have to pay?
You'll be given a copy, and you can set up payments at the window. Anything else, Ms. Cruz?
Don't know whether or not there was a no contact order attached to the charges. I don't believe there was. I'm going to suggest to leave that to non.
Well, if there's I'm assuming there's another existing one. I don't think there's one attached to this one. So if there's any other orders, you confirm that.
Yeah, there's none attached.
Okay, we did not do a pretrial no contact order here. So all we're doing is saying if there's other orders, now maybe the order that we're dealing with has been resolved at this point. Well, then there's no other orders. But if there is another order, you need to comply. Okay, does that make sense, Ms. Cruz?
Yes, sir.
Okay, and there's not. Mr. Ratfield, anything else?
No, nothing else. Enough talking. So we're going to go to. That's not right. Don't worry, I'm gonna fix it. We're not there yet. Gonna go to Texas. I think I fast forwarded it enough that we're starting the bond hearing. So yeah, everybody here has, when you're in Texas, if you've been in jail for 90 days and you haven't been indicted, you are allowed a bond. You have to have a bond. So most of these are those type of cases. They've been in jail for a while, and they've not been given a bond.
The victim gave the officers the case number from the March incident.
Hold on, I'm going to rewind it a little bit.
And that's before police initially arrived.
27, Ernesto Chinhedro Perez.
Danny Hyder for the defense. Defense is ready.
Michelle Souza for the state, and the state's ready.
Thank you. Outside 28, Jasmine Underwood.
Shelby DeLisi for the defense. Defense is ready.
And Allison Lane for the state, we're ready.
Outside 29, Jose Gadam Wilmer.
Danny Hyder for the defense. Defense is ready.
Gadam.
I need a umpire for the state. State is ready.
Thank you. Outside 30, Pedro Jose Zalazar Chalel.
Yes, Judge. This case was removed from the calendar at request of defense counsel. He's in trial in Division 4 right now.
All right, very good. Thank you.
And Judge, that's my last matter. May I be excused?
Yes, thank you. You're excused.
Thank you, Judge.
All right. Are there any other announcements before we get into handling the cases? If not, counsel, Anita, can you pronounce your name for me? The last
Emma Pariana.
Emma Pari. Pari, got it. Okay, I got it for now. All right, dears, go ahead and take it from here and we'll handle the calendar as efficiently as possible.
Yes, Your Honor. Position number 1,
Okay,
Ayinde Alexander.
We are ready, Judge.
I'll hear it.
Your Honor, this is a single count of aggravated assault against the defendant. On March 25, 2025, DKPD responded to 6201 Memorial Drive at the Texaco gas station on a shooting. When police arrived, neither the suspect nor the victim were on scene. However, they discovered evidence of shooting. There was an area of blood located on the pavement with a black belt on top of the blood. And there was a pink Nike hat with a pair of Nike shoes also nearby. Officers observed 14 9mm Lager shell casings at the scene. Surveillance captured a male wearing a black hoodie and gray pants walking towards the crime scene with a handgun in his hand about 6 minutes before police initially arrived. The video, however, does not capture the actual shooting. The shooting was also was called in by a witness, Gary White. Mr. White stated that while walking his dog, he heard the gunshots. So he went inside his apartment, which was nearby, and looked in the area of the shooting. He observed 3 individuals pick up the victim from the ground and put him in the backseat of a white SUV before leaving the scene. On August 10, 2025, DKPD was dispatched to a Dollar Tree located at 3447 Memorial Drive in reference to a person wanted. The 911 caller, Tavion Williams, identified himself as the shooting victim from the previous incident, the March incident, and told the police that he just saw the man who shot him. The victim said he only knew the man as Chrome, and that Chrome was currently at the BP gas station on Memorial Drive, standing by a gray Honda Accord parked between the gas station and a nearby apartment complex. The victim gave the officers the case number from the March incident, and officers arrived at the scene and indeed observed the man with the exact description near the Honda. He was accosted, and the driver of the vehicle, of the Honda, who was there to pick up his niece, stated that he knew the defendant by the name Chrome only. Therefore, the defendant was arrested. He has 8 cycles. He has a 2012 possession of marijuana out of the cab, for which he got a conditional discharge for. Then he has a 2013 obstruction conviction out of Gwinnett. He has a 2018 possession of marijuana as well out of Gwinnett, for which he was convicted. He has a violation of probation from 2019 of that case. Then he has a 2019 obstruction conviction out of DeKalb. Then he has an open case in DeKalb, which is possession of firearm during the commission of a felony, possession of Schedule 1 controlled substance, and possession of Schedule 2 as well, controlled substance, and possession of marijuana. This case was opened in May of 2024. He currently has a $1,500 cash bond on that. This is a 90-day case, therefore he is entitled to bond. State is requesting for bond in the amount of $100,000. State is asking for ankle monitor, house arrest. State is further asking for him to report to pretrial service within 24 hours of release, that he is not to have any weapons, he's not supposed to return to the incident location or have any contact with the victim. State is also asking for no drugs and for him to be subjected to random drug screens. The case has been scheduled for grand jury presentation on December 2nd, 2025. His open case also has a pending motion to revoke bond that is yet to be calendared. Based on the Ayala factors, state believes that defendant is a danger to the community. He shot the victim multiple times, striking him at least once, leaving him for dead on the pavement. Any one of the 14 bullets could have struck an innocent bystander. And based on that, the state believes that he acted with malice and intentionality. State is therefore asking for the bond mentioned.
Thank you, counsel.
Judge, this Madam DA was not present at the preliminary hearing, which occurred on October 30th. And on October 30th, Detective Kearney testified to the following: that alleged Mr. Williams, who is the alleged victim in this case, it does show, the video does not show the shooting, but it shows Mr. Williams has at least a 10 to 12 inch item in his hand, which is either my client had contended with an ice pick, or it was a long screwdriver attempting to come after and stab my client. He had testified also, Detective Kearney said that this could be a case of self-defense, and he testified to that as well. My client did not shoot 14 times. He only shot twice in self-defense. These parties have known each other for several years. These are not a stranger on a stranger thing. And the whole thing that caused instigated the fight or the disruption between these two individuals was based on the fact that my client basically used some homophobic slurs to the individual. They were all drunk. And as a result, Mr. Williams got upset. He
Kelly, you
prior
already
to
did that.
brandishing
Thank you.
ice
Thank
pick
you,
or a
thank you.
screwdriver, he had brandished a weapon against my client. My client tried to leave several times, and he continued to follow my client around the parking lot. And as he tried to leave, that's when the shooting occurred, because he would not leave my client alone, and my client acted in self-defense. He's 30 years of age. He has a GED. He has one son, 7 years of age. He's been in Georgia 18 years. He stays with his mom. He's been doing DoorDash for 7 years. All the other prior arrests, while I'm not condoning them, are all misdemeanors, which he's resolved, except for this current one, which is currently he's not been convicted of that or anything else. We'd ask for a reasonable bond of no more than $25,000 and any other conditions the court may see fit. But this is a case that we spent probably about a half hour, 45 minutes on the prelim on October 30th, and it was clearly a case of self-defense, and Detective Kearney kind of admitted to that. Thank you.
All right, Mr. Katz, you said he had a weapon. What type of weapon? Are you still referring to the long object, or were you referring to something different when you said they were on the?
They can't tell from my client contends it was an ice pick. Detective Kearney said from the video it showed it to be a long object, either a long screwdriver or some type of knife.
Okay, I just wanted to make sure. It seemed like when they relocated, you used the term weapon, and I got it. It's the same thing you were describing, the long.
And the victim had this in his hand, and he came after my client.
All right, very good. Thank you. The court is going to set bond at $40,000.
Thank you.
He'll have to be on an ankle monitor, house arrest. He'll report to pretrial within 24 hours of release. He is to have no weapons, no drugs, submit to random drug testing, and to have no contact with the victim or any witnesses, and he cannot go back to the incident location.
That's fine, Judge.
All right, very good. That's the court's order.
And the DA, the court or the Madam DA will complete that order, Judge?
Yes, I would. If you could please provide me with the address for the house arrest, that would be great.
Sure.
In the chat.
Okay, thank you. May I be excused, Judge?
You're excused.
Thank you.
Next position is position number 2.
I'll hear it.
And this is a motion to modify.
That's correct. And Judge, I just asked my client, Ms. Barber, to come to her camera. She is present for the motion.
All right, Ms. Barber, this is Judge Haynes. If you can please turn on your camera. In order for you to be in the proceedings, you must show yourself. Thank you. I think I just saw you pop on. Thank you, ma'am.
Thank you, Your Honor.
Lacey, that's
And we can-
amazing.
If,
Congratulations.
given this is a motion to modify, do you want some background information on the case first, or would you like the defense to go first?
Let me just go ahead and hear from the defense and I'll see how much more I need.
Okay.
Thank you.
Thank you, Your Honor. So Judge, we are here to modify certain conditions of Ms. Barber's bond. Ms. Barber posted a $75,000 bond on September 27th, 2025. She has been out of custody since that time without any issue. As part of the conditions for the bond, which she posted in September, she is to be on an ankle monitor with house arrest, to reside at an address, a Jonesboro address, and is only permitted to leave the residence for medical emergencies, court appearances, and to meet with counsel. She's also to report to pretrial services, not be in possession of any firearms, have no contact with any of the alleged victims, and not return to the listed incident location. Today, Your Honor, we are asking the court for two very, very small modifications. The first is to allow Ms. Barber, as one of the exceptions to her house arrest, to be allowed to engage in pre-approved work. So Ms. Barber, as far as her work history, prior to his arrest, was working as a forklift operator at Altium Packaging, and she believes she's going to be able to eventually get into another sort of warehousing job with her forklift certification, and she has been working on that diligently. But at the current time, her ankle monitor conditions do not permit her to do pre-approved work as part of the sort of carved out exceptions of her ankle monitor conditions. So we are asking the court to allow that as an exception so that she can submit pre-approved work to pretrial services and allow her to actually engage in employment. Another reason for that is the ankle monitor is very expensive. It's typically about $300 a month. So she needs to be able to work to produce the income sufficient to actually pay for the ankle monitor so that that doesn't result in any sort of involuntary violation of her bond conditions. The second modification we are asking for, Your Honor, is to change the address for her house arrest. She was previously living with, I believe, her mother or her grandmother at the address that is currently listed in the bond order. But since Ms. Barber is planning on getting back into work, she's going to, or hoping to, move to her sister's home, which is also in Jonesboro. We do have the address for the state and for purposes of the order, because her sister has a vehicle that would allow Miss Barber to actually commute to and from work once she is able to actually get a stable job that she's been working to find. So those are the two conditions that we are seeking to modify in this case, Your Honor. As I mentioned, Miss Barber has been out of custody for about 2 months at this point without any issues. My understanding is she has no felony convictions or felony arrests other than this present case, and that her criminal history is otherwise very limited. She has significant ties here in Georgia. She's been here since she was 2 years old. All of her family is in the area. She's been living with some of them and is hoping to go and live with others for purposes of helping her work schedule. So that is our request, Your Honor, that the court modify the motions as such.
All right, Ms. Layson, what's your response?
So as to the address, the state actually has no issue with the change of address as long as it's not near the victims. But as to the ankle monitor, she's only been on bond for 2 months with this ankle monitor. She doesn't have a job currently lined up or a schedule in place. And so the state would object to any change in ankle monitor conditions at this time. She doesn't have a very lengthy criminal history. However, just a brief facts of this case, she approached the victim at a restaurant where there was a baby in the car and tried to shoot. Fortunately, the gun didn't go off, but she then struck the victim in the face with the butt of the gun. And this is all surrounding a domestic type situation. And so just with only 2 months on bond, the state would be opposed to taking off the ankle monitor at this time. She needs to be monitored.
I don't think he was asking to take it off, or were you, Mr. Hydrick?
No, I was not asking to have it removed, Judge, just to allow that additional exception for her to submit a pre-approved work interview or work schedule to pretrial services, and then they can approve her work schedule once she's able to secure it, to allow her to work, produce income so she can pay for the monitor and to live at her sister's place so she can do that more effectively.
So it's more of a request to change the conditions to allow her to, I guess for the pretrial to pre-approve her ability to be able to work. And they would have to pre-approve the working conditions or the working location.
Yes,
That's-
Your Honor.
And that's fine. My notes were not, I was under the impression they were asking to have it removed,
Okay.
but allowing for the work exception once she provides a pre-approved schedule would be fine.
Okay, very good. Okay, the court will grant the motion to modify. Will Mr. Heydrich, will you be preparing the order?
I can, Judge. I have some proposed language submitted by
Or
the
if not, is it easier for the ADA to prepare it?
Either way, I can prepare it. I was planning on preparing it, but
I can send the language that we've proposed to Ms. Layton.
Yeah.
And
Okay.
if there's objection to it, we can change
Okay.
it as necessary.
Sounds good. We'll go ahead and take the next matter, Ms. Impari.
Position number 7, Christopher Cadet.
And Your Honor, may Ms. Barber be excused?
Ms. Barber may be excused.
Thank you, Judge.
All right, we'll move on to Christopher Cadet.
and is we are ready on position 3 as well, after position 7.
Okay, very good.
So this is a 90-day. Would you, I believe they're
That's
currently
what I
on no
heard
bond.
too,
Would you like me to
Jim.
proceed
That's
as
what
if
I
it's a traditional bond hearing?
No, you can kind of tell me what you expecting, what your sort of your wishes are in terms of what
Okay.
type of bond.
All right, I will just say that the arrest date for the Christopher Cadet was on August 13th, 2025. This happened at the Strokers off Brockett Road. He's charged with ag stalking. Essentially, the defendant's criminal history is he's got a 2023 family violence battery and disorderly conduct out of DeKalb State Court that is open and pending with the same victim. And then he was arrested August 13th, which is this case for the ag stalking. And there are bond conditions on that previous case for stay away conditions. It's an ex-boyfriend of the victim that is the subject of the warrant. The state is asking, even though this is a 90-day case and he's entitled to a bond, we are asking that bond be no less than $50,000. There also be a special condition of house arrest with an ankle monitor prior to release, no contact with the victim, no drugs or alcohol, and report to pretrial services, random screens, and no firearms. And then he has a couple other misdemeanors out of other states, but they're from the early 2000s. But the 2 most recent ones involve the same victim.
Okay, very good. Okay, counsel.
Thank you very much, Your Honor. Judge, Mr. Cadet is 43 years old. As the state mentioned, he has no felony convictions, no felony arrests at all prior to this alleged incident. The DeKalb misdemeanor that the state represented is, again, still pending. He's working with our office on that case. He has entered a plea of not guilty, and they are waiting for a trial date in that case. But he, of course, is presumed innocent of that matter and maintains his innocence in that case. As to this case, Your Honor, this kind of deals with a very complicated relationship between Mr. Cadet and the alleged victim. So Mr. Cadet, as I said, he's 43 years old. He has a 4-year-old son with another person, Ms. Gabrielle Richardson, who is his ex-wife. I am expecting her to be present today. But after he and Ms. Richardson ended their relationship around 2021, 2022, that is when Mr. Cadet becomes involved with the alleged victim in this case. From the inception of their relationship until the time that Mr. Cadet is arrested, and frankly, even after that, since he's been in custody, the alleged victim has issued against Mr. Cadet, from my count, 5 separate temporary protective orders in that time. The first is dated in 2023. This is one that she files, then later moves to dismiss because she says she feels he's no longer a threat. So that TPO is removed. Then in 2024, she files another TPO, moves to dismiss that TPO because she doesn't want it in place anymore, then asks that it stay in place. And then in 2025, After Mr. Cadet is arrested in August of this year, she moves for another TPO. That TPO is dismissed because she doesn't show up for the actual TPO hearing. And then after that one, I believe this was filed in October, the beginning of October, she submits another TPO in which she alleges the facts or the allegations of the incident that are underlying Mr. Cadet's arrest in the aggravated stalking. In all of these filings, as I've reviewed them and been able to collect them over the past few months since the last bond hearing in this case, the alleged victim has submitted that she was at one point pregnant with Mr. Cadet's child. That is not true. They do not have any biological children together. She, in the most recent TPO filings, alleged that for this incident that we are here for this aggravated stalking case, that Mr. Cadet went to her school, dragged her into a car, was threatening her. But the police report for this incident very clearly shows that the allegations are that Mr. Cadet went to her place of business, which is a strip club, I believe it's called Strokers, and contacted her at work.
There you go.
So across all these filings, Your Honor, there are multiple inconsistent statements about the exact nature of her relationship to Mr. Cadet, what actually happened on the alleged incident. And this just goes to show these multiple filings over and over again, even after Mr. Cadet is in custody, in all of these inconsistent statements that are found therein, it has only worked to Mr. Cadet's prejudice. He has never harmed this person. I understand that there is an alleged misdemeanor case, but again, he maintains his innocence. There is no allegation of any sort of violent contact in this case either. It is just contact in violation of a TPO and the bond conditions of that misdemeanor case. But he has never been violent towards this person, and she has consistently made these inconsistent statements that have restrained his liberty and unfortunately kept him in custody now for 99 days, I believe, as we are here today. We did file an emergency motion in this case early back in September because Mr. Cadet was at risk of losing his apartment, losing his employment as a result of being incarcerated, and lo and behold, that's exactly what has happened. Since he has been in custody, he has lost his apartment. I've been able to speak with many of his friends and family members as well as his employer, and they will allow him to come back to work. But this is not the first time that something like this has happened, Your Honor. Mr. Cadet has faced homelessness before as a result of these TPOs effectively removing him from the home where he was staying with the alleged victim. And these are all, again, based in these inconsistent or just not true statements about the nature of their relationship or what's actually going on in these allegations. The police report was very clear, and the officer very clearly testified at the preliminary hearing in this case. They don't share any children together whatsoever. And again, the allegations from the police report and from the officer are very, very different than what the alleged victim is submitting in these legal affidavits for these TPOs. So there is a lot going on here, but again, Judge, it has only worked to Mr. Cadet's prejudice. It has affected him greatly, and I have a lot of questions about the veracity and credibility of a lot of the things that she is saying. So once he gets out, Your Honor, he's likely going to have to return home to his ex-wife temporarily while he again works on building up income and finding a place to live. His employer has said he's shown up to work before wearing the same set of clothing multiple days in a row as a result of stuff like this. So this is just a very, very twisted situation, and it is very unfortunate for Mr. Cadet. I will say that the most recent TPO, he was brought down at the jail to the TPO hearing. He consented to whatever the conditions were of the most recent TPO, to include no contact, and I'm sure there are some other conditions that are a part of that. He doesn't want anything to do with this person anymore. She has caused him quite a lot of tribulation. But through the history of their relationship and these TPOs, she's taken him on trips. She's invited him back home. It's the same story over and over and over again. So ultimately, Your Honor, we are submitting to the court that Mr. Cadet is a very, very good candidate for bond. This is just a very, very difficult situation. We'd be asking that the court set bond in the amount of $5,000. We, of course, welcome a no contact provision. We would object, of course, to house arrest with an ankle monitor. given his situation, his loss of his housing stability, that's just going to frankly be an impossibility for Mr. Cadet. But if there are any other conditions that the court finds appropriate that are not a financial burden to him, I know he's going to be able to maintain those conditions. He just needs to get out so he can, one, return to his family, and hopefully find a new place to live and continue his employment.
Right, let me ask, ADA, the aggravated stalking, is part of that made up of all of these TPOs that were filed, or is there a different set of facts for the charge?
The facts that give rise to the aggravated stalking warrant occurred at Stroker's, where she is employed. He went to the place of business. He entered the business and found her. He grabbed her from behind and told her he loved her and asked her, like, why is she doing this to him? And so that's in summary, the facts that give rise to the aggravated assault warrant.
Okay, got it. All right, very good. The court is going to set the bond at $15,000. He is to have no contact with the victim, report to pretrial within 24 hours, cannot go to her place of residence or business, no firearms, no drugs. And was there anything additional from the state? Did I cover it?
I know the ADA assigned the case was requesting an ankle monitor. I don't know if the court's inclined to grant that, but just putting that on the record.
Yes, I'm going to not grant that at the time. If at this point he doesn't appear, there's going to be ability to pay for that or what have you. But at any rate, $15,000. Other than that, everything else stands other than the ankle monitor.
Okay.
All right, very good. Okay, that concludes that matter. We'll go back to outside 3. Let's see what we have there. That is the case of Richard Gregory Barnes.
Yes. And just see. Briefly, he was arrested on August 18th, 2025. He had bond was denied at first appearance and bond was denied in September 18th, 2025. This incident occurred at the 2300 block off Terrell Avenue. It's a burglary in the first degree. The officers responded to Terrell Drive regarding a suspicious person. Eyewitnesses indicated that a male known as Richard had been breaking into 3 homes within that street. They later observed him walking away from the front door area of one of the homes. He tried to say that he worked for a property owner by cutting the lawn, and wanted to obtain his equipment from inside one of the homes, but he didn't have permission to enter the homes. When officers did enter one of the homes that he was seen, they noticed copper piping was removed, that was located in a white box, and the home had been disturbed. The defendant does have significant criminal history, but I will just state most of it is drug related. He's got several thefts and drug related arrests. The state's recommendation, given that this is a 90-day bond case, would be a $30,000 bond. Pretrial services with a drug evaluation and random screens, stay away from that street, and no contact with the witnesses and victims in the case.
All right, counsel.
Your Honor, Mr. Barnes has been in custody for over 90 days. And
I have a question about that. So his no contact order is to stay away from that street, all right? For how long does he have to stay away from that street? How long does that last? Does it last? I mean, he's not convicted yet. So let's pretend he does get convicted of burglary, 3 homes, same street. Like, I wonder how long. I just want to know if it could be permanent.
is now entitled to a bond. Since his last hearing, he has continued to take the necessary steps to show that he is an excellent candidate for his release. He's working with a social worker from our office, Ms. Hendricks, to find mental health and drug treatment options. So we are completely open to that eval condition. He acknowledges that he's been self-medicating with drugs to deal with some mental health issues for a while, and he's ready to stop. Additionally, his longtime friend confirmed just this week that he has a place to stay and a means to financially support himself if released on bond. He is going to be a live-in caretaker for his longtime friend Terry Farmer's mother at her house and provide her with assistance and help from various tasks and chores. Ms. Farmer's mother has always been fond of Mr. Barnes, and she is happy to have him stay with her. So I'm happy to provide an address to the state for that. Mr. Barnes is a loving and caring grandfather with supportive adult daughters who both live locally and who care for him deeply. He suffered a TBI at age 7 when he was hit by a car, and some of that damage was irreversible. As a result, he struggled in school, and his family reports that he was never the same after. Later in life, he became a professional boxer, and the hits he took resulted in even further cognitive damage for Mr. Barnes. He has suffered many personal setbacks and lost many loved ones. His mother died in 1972 from breast cancer when he was only 6 years old. His father became a single parent of 7 children, the youngest only 2 years old at the time. And then his youngest sister, Miss Barnes, died outside when she was around 10 years old. So,
Ma'am, what the hell? This is not relevant to anything at all. Something that happened in 1972 did not make him burglarize these houses. Will you get on point? Judge, get a hold of her.
he has had a traumatic upbringing. A lot of that has sort of exacerbated his issues that he now acknowledges and is ready to get help. He had another brother die in a car accident in his early 20s. His father died when he was very young, and he became unhoused, and his mental health declined significantly. And then he has also lost a sister. So 7 children, and it looks like.
Yeah, I've got that. Let me ask you, Mr. DeLisa, because I mean, it's obviously he's been through a lot of trauma throughout his life. You mentioned that the social worker is assisting him from your office. If he is released on bond, will the social worker continue to be able to assist in making sure he gets in the right types of programs? Or how does that work with your office?
Smith.
Yeah, so he will have to apply, and he's aware of this. So once he bonds out, he does need to apply to continue with the services. So long as he does so, he will still be connected with the social worker, and be able to connect to those resources. So a lot of the help right now is like, hey, you're in custody. When you get out, these are the options. And then once they are out, there is follow-up there to make sure that they understood what you told them when they were incarcerated, and can go through those steps. So Judge, we do think, a drug eval is appropriate. We're okay with a mental health eval as well, and to follow up with any treatment. He does have limited resources right now, so we are requesting a $5,000 bond.
All right, thank you. Okay, the court is going to set the bond at $10,000, and with the conditions as laid out by the state, report to pretrial within 24 hours. He'll have to have random drug screens. No, of course, no drugs, no contact with any of the victims, stay away from any of the locations. And I'm going to require him to make that application with your office, with the PD's office, to receive those services, continued services from the social workers there. And you've already indicated where he will be staying. And he'll be working and staying in the same location. Is that correct?
Yes, Your Honor, that's my understanding.
Right. So if that's the case, he is going to basically be on house arrest at that location. As a matter of fact, I'm going to reduce this down to 8,000, and he'll be on house arrest at the location where he is staying and working. I think that, except for having to go to any services, legal or medical type services. Is everyone clear?
And if you'll just provide me with the address, you can send it either through the chat or email. And then, Your Honor, I know that requesting ADA wanted a drug evaluation.
Yes.
Was that part of the services he was already receiving, or is that going to be a separate condition?
I'm saying that he needs to have that evaluation.
Okay.
Absolutely, yes. And the mental health as well. I think as counsel mentioned, they had no issue with the evaluation for mental health and drug evaluations.
Right, got it.
Mm-hmm. And just to be clear, I know that, we have Winway, we have the community health center, that type of thing. Is that typically what y'all using, or is there anything else provided through the courts? It's just going to be the community health, pretty much on Winway. That's probably the only thing that's available for them to typically get the evaluations. Or y'all know what I'm speaking of? Maybe not.
Sorry, go ahead.
I've heard that Winway is a place that is done. I'm not sure if pretrial services has like a list of places.
Okay, but maybe it'll all be handled through pretrial, I guess, either way. All right, thank you. That'll be the court's order. Okay, Ms.
Your Honor.
Yes, ma'am.
Before we call another one of mine, can I please hop into a breakout room with Mr. Smith to explain his consent bond order that was signed yesterday so he can get out of here?
Yes, that's fine. We can go ahead and put y'all into a breakout room. Are all private attorneys been handled?
Yes, Your Honor. Is position number 8 yours? 8 to 10?
Okay, we're going to do 8 to 10. Thank you.
Okay.
All right, the matter of
Your Honor, those are Ms. DeLisi's cases.
okay.
Then
Yeah, so
move
Ms.
on to
DeLisi, she just went into a breakout room. So do we have something else?
position number 12.
That's mine.
Okay.
That's
All
a
right.
reconsideration. So if you could.
All right, I'll hear the matter of Prince Hazel Campbell.
And I apologize, Your Honor. Did you want the defense to proceed first for the reconsideration?
Yes, I'll hear it.
Okay, thank you, Judge. Your Honor, Mr. Hazel Campbell is 19 years old. He has been in custody as of today for 232 days as of his arrest back in April 3rd of this year. Mr. Hazel Campbell received a $28,000 bond at his first appearance that was granted by Judge Axum in the Magistrate Court. And today we are asking the court to reduce Mr. Hazel Campbell's bond to an amount of $10,000. Since his arrest and previous bond hearings, Your Honor, Mr. Hazel Campbell has had no disciplinary issues at the jail. He has not picked up any new charges. He has been on model behavior for the quite lengthy duration of his incarceration. As to the case, Your Honor, Mr. Hazel Campbell absolutely denies these allegations. He is going to be going and living in Stone Mountain with his adopted parents and siblings. He has very significant ties here in Georgia. He is actually from the Metro Atlanta area, and all of his adopted family is here with him. He's going to be going and living with several of them. Prior to his arrest, he was working a construction job. He is confident he'll be able to return to that work once he is able to post bond and get out of custody. He is also working on getting his GED and has taken some steps in the jail to try and get into some classes. Some of the pods of the jail offer courses and things like that, particularly in the compliance dorms. Unfortunately, we haven't gotten him there yet, but he is making strides to do that while he is in custody. So At this time, Your Honor, he is unable to afford the bond as currently set, nor is his family. And for all these reasons, we submit that he is a good candidate for bond, and we'd ask that the court reduce it again to $10,000 cash surety or property.
And you said, what's the current bond again?
$28,000, which was set at first appearance.
Okay, very good. Thank you. Counsel?
Your Honor, state believes that bond asset is fair and reasonable. He does have some juvenile criminal history, but currently most of them were battery adjudicated delinquent, and he had a burglary delinquent adjudication as well as a juvenile. Currently, he has an open case for criminal trespass, eluding, and theft by receiving, which is also in DeKalb, for which he's out on bond for. I believe bond in that case is about $10,000. So state believes that he's a risk to reoffend, and bond asset is fair and reasonable.
All right.
KB.
The court will reduce the bond to $15,000
Thank you so much.
with all of
Thank
the
you.
same conditions from the first bond. And would there be anything additional from the state?
No, Your Honor.
All right, that'll be the court's order. All right, our next matter.
Our next matter will be position number 17 and 18. I don't know if it's for Miss
I
Delisi.
believe those are Miss Delisi's, but it looks like she's
He's back.
Okay, then.
And I'm sorry to interject. Our victim reached out to me on
She's back.
position 2 and had wanted to make a statement. I just wanted to see if she was still on
I'm
the
sorry,
call.
which
If it's okay.
number? I missed
It was
which number?
position 2 and Morje Barber.
Okay, let me see.
I just wanted to call for her if she was still on the call.
Okay, go ahead.
Is Latesha Dinkins still on the call? If so, turn on your camera. Okay, I'll have the victim advocates reach out to her.
Okay, very good. Thank you.
Thank you for letting me interject.
Sure. Okay, so we are now back to Ms. Delisi's matters. Which numbers were they again?
Position 9 through 10. Milton
Okay,
Fiction.
9 through 10.
Yes, Your Honor.
Okay.
8 through 10.
It's 8 through 10,
8
that's
through
correct.
10.
Right. I'll hear it. This is not a 90-day, is it? No.
Do you want me to go first, Your Honor?
Is this a first bond? What is, it doesn't say on here. What am I looking at?
It's just a motion to reduce bond.
Oh, it's a motion to reduce. Okay, I was looking for it on a thing. Yeah, let me hear from you, Ms.
Thank you,
Delisi.
Judge. So right now, across all 3 cases, Mr. Ficklin has been in custody for 196 days with a $24,000 bond. He has been unable to post that bond. He does have a 22-year-old daughter who is going through a lot right now. And it is very important that he be able to get out to be there for her. Her mother is in the hospital and has not been doing well. So it's very important to him that he be able to be there to support his daughter. Now the $24,000, he has not been able to bond out with that. So Judge, we are asking to reduce this to $2,000 on each count, which would be $8,000 total.
What is the current for each count at this time?
It's $8,000 for each count.
Okay, thank you. I'll hear from the state.
All right, the defendants, of course, in on 3 battery warrants that were sent up from state court. The first incident was in March of 2025. The second was May of 2025, and the third was April of 2025. So these happen in quick succession with each other, pretty close in time. The defendant does have, let me see. and they're all the same victim too. But he does have a 2023 family violence battery with a different victim that he was sentenced to. A 2022 family violence battery out of DeKalb with a different victim. A 2020 family violence battery out of Rockdale with an unknown. We were able to obtain the victim at that point in time. He does have a 2015 arrest for cruelty to children in the third, ag stalking, and family violence battery out of DeKalb. That was a different victim. And a 2015 family violence battery out of DeKalb, a different victim. And that is just dating back to 2015. There is older history as well that is older than 2015 that I can go over if Your Honor would like, but the state is opposed to any reduction. We find that the bond is fair and reasonable as it is. And if you'd like me to go into some of the specific facts, I understand the victim is recanting and may be here to speak on behalf of the defense, but the state's position is that the bond should remain as is.
Okay, so just so I make sure I've got the ones we have here, 325, 425, 525. And in some of the history, the 2015, the cruelty to children, and then the family violence, was that all at the same time? Was that just
So in 15, there were 2 June of 2015 cases that happened in quick succession.
okay?
And then there was the September 20th, a December 22, a January 23. That was another victim.
Were these all family related matters?
Let me see. The current cases, they are boyfriend and girlfriend that had lived together. I don't know about the older cases, but I can see what I can find if they were family related or romantic partner related.
Okay, I just kind of curious as it, but this, so the current one is a relationship, not a marital relationship, but
Correct. Yes,
okay.
intimate partners, but not married.
I got it. Okay, very good. And Ms. Delisi, you're saying she's trying to recant in these issues? Is that what I'm understanding?
Your Honor, I do not know what the victim is saying at this time. My understanding is that this relationship is over and we absolutely welcome a no contact order.
Okay, does the victim here wants to speak or no?
I am not calling a victim.
Okay, very good. I just wanted to make sure. Okay, I just want to be clear on that. All right, very good. Okay. The court's going to, it's how many, I'm sorry, the total lockup time is how many days?
196.
Okay, I just want to make sure I had that written down right. Court's going to reduce each count down to $5,000. And all the stipulations from the last bond will remain. Is there any additional stipulations from state?
Let me.
We missed your birthday.
I know we would. I'll double check and make sure.
2 days ago? Was it 2 days ago? Chris, your birthday was like 2 days ago. Happy birthday. Happy birthday. Was it a good one? Was it?
Sure, but I just want to make sure that there are conditions of no support directly or indirectly, or sorry, no support, no contact directly or indirectly.
And you can just tell me now, and then we'll just say these are additional if they're not in the in the other bond.
Let's see. No contact directly or indirectly with the victim or her place of business. Report to pretrial services within 24 hours of release. Possess no weapons, just given domestic violence stats. I don't know if there's any allegations of drug abuse or drug issues, but to the extent there is a drug evaluation and recommended treatment.
Okay, court will incorporate all of those into the order. No contact at the place of business or residence or any other location. Pretrial appear pretrial within 24 hours, no weapons, and a drug evaluation and treatment if needed. The evaluation, and you must complete any treatment that may come out of the evaluation.
Okay, thank you, Judge.
Oh, thank you. And any other conditions that were in the prior bond shall remain in effect. Okay.
Next up is position number 13, Reginald Hens.
No. Listen, we could go another. Whoo!
All right.
No, shh. Because they're so interested, we could go another hour and a half easy. But we can't. I gotta start OJ. I gotta get this day started. I wish I could keep going. Today, I just want to keep going. It's hard for me to just stop today, but we are going to. But I'm gonna start my OJ stream, and I'll have more for you tomorrow. I hope that you guys have a great night. Day. It's not even late out yet. I'm telling you, have a good night. I thought you said in Discord 2 days ago it was your birthday. Hold on. In general chat. Hold on. I must have misread it. Oh my goodness. Christy TYP, not Christine DD. I got my Chris's all mixed up. That was my bad, guys. I'm sorry. It was Christy's birthday, not Chris's birthday. Come on, guys. Get with it. Read. Anyway, no one said happy birthday to you last year. So there you go. That was for last year. Yeah, different Chris. I love that we have more than one Chris, though. Alright, guys. Behave tonight. I will see you tomorrow. Love you all. Thank you so much. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,